Hello and welcome to this live broadcast from the Ottawa Business Journal. My name is Michael Curran. Today's topic is a hot one. What to do about unvaccinated employees. Public sector employers, notably the federal government, announced weeks ago that employees would need to be fully vaccinated. What's new in the past several weeks is how employers deal with unvaccinated employees. It started with universities, then hospitals, then municipalities, now possibly even our local police. I'm referring to employees being put on unpaid leave for not adhering to vaccine policies from their employers. And it's not just the public sector. Air Canada, for example, just weeks ago suspended approximately 800 unvaccinated employees. So today's show is dedicated to this question: what to do about unvaccinated employees. Let me introduce our legal expert for today's discussion. He graduated with an LLB and LLM from Dalhousie Law School way back when, and today he's a partner at Emond Harnden, a boutique law firm in Ottawa that specializes in management side, labor, and employment law. That law firm, in Emond Harnden, represents many of the city's largest employers, both in the public and private sector. We are happy to have them sponsoring us today. And here is our guest, Porter Heffernan. Hello, Porter.
Hi, Michael. Thanks very much for having me here.
Well, we're thankful for you to be here because, I think this is a topic that is on the top of many employers' minds, both in the public and private sector. And maybe, Porter, as we begin our discussion, let's just acknowledge that the legalities around this are changing very rapidly. There's really no case law and few legal decisions on that. And let's just make it clear that if someone's listening today, this does not constitute legal advice. You really should talk to a lawyer. Having said all that, Porter, we do want to explore these issues, and we're going to begin, I think, with something that is kind of the foundational question before we get into today's specific topic. Is it entirely reasonable and defensible for employers to insist that employees who enter the workplace are fully vaccinated? What do you say, Porter?
I'd say that's a very good question. That one question really captures 90% of my practice for the last 3 months, and I think that of most of my colleagues, both within the firm and outside. The starting point for the answer really has to be the unprecedented events of the last 2 years. None of us have experienced anything like this in our lifetimes. And we know that the death toll from the pandemic has been remarkable: 30,000 in Canada, 763,000 in the US as of yesterday. For comparison, the CDC data on flu death tolls for the last 2 years in the US were 20,000 last year and 28,000 the year before. So there's no question that the pandemic poses an enormous risk to public and individual health and safety. As you know, Michael, and as many of our viewers will know, employers in both Ontario and the federal sector have a statutory duty to take all reasonable precautions to protect the health and safety of their employees in the workplace, including obviously the risks posed by the pandemic. We know that the benefit of vaccination is just as clear as the risks posed by the pandemic. We've got great data from Public Health Ontario and from other public health agencies in Canada that shows that, for example, the mRNA vaccines are 85% effective in preventing symptomatic infection, and similarly effective at preventing asymptomatic infection and therefore transmission. So it's very clear that the vaccines are a critical measure to protecting the health and safety of employees in the workplace. And with that in mind, in my view, it is certainly reasonable to implement a policy which requires employees working on site to be vaccinated absent a legitimate medical exemption or other objection based on the Human Rights Code.
That's great. Great start. So what I heard there clearly was that this is a unprecedented health risk, and some unfortunate statistics on fatalities there. That employers have a legal obligation to keep people safe, and from all the evidence, it appears that the vaccines can be very effective. So that is, as we said, the foundation for today. Let's take a little bit of an ahead look, an advanced look at three topics we're going to talk about. We've divided the show, as we often do, into three parts. So the first topic is it all starts with a vaccine policy. We're going to talk about that in about 20 seconds. Next, we're going to look at employees who do not abide by that policy. And then lastly, we're going to look at how employers should protect themselves if they take action against those unvaccinated employees. All three of those are topics. I will point out to everyone watching that this is a live show and you have an ability to pose questions. Just use the chat function. Sorry about that. So let's dive into that first topic. And as I just indicated, it all starts with a vaccination policy. And Porter, let's get into this. So why is a vaccination policy the starting point for all of this?
Well, as anyone who has the pleasure of dealing with a labor and employment lawyer in their business knows, we love nothing more than talking about policies that you should have, and there's good reason for that. No matter what business you're in, whether or not you're unionized and whether or not you're private sector, it's very important for your staff to know the rules that they have to follow. Those rules have to be clearly set out. Staff have to be told in advance what they are and given an opportunity to comply before the rules are enforced. A well drafted policy achieves exactly that, and that is true in this case as in so many others.
And walk us through at a high level what that policy should include, Porter.
Absolutely. So the policy needs to build a foundation for the approach you're going to take to vaccination in the workplace. It's critical that the policy lays the groundwork for the approach you're taking. So the policy should explain the rationale that leads to its implementation. This would include referencing the risks presented by COVID, any relevant regulations or government directives that might apply to you given the nature of your organization, and the employer's commitment to protecting the health and safety of staff. The policy also needs to clearly set out what is required with respect to vaccination. In most cases, this is going to mean setting out a requirement for employees to provide either attestation or proof of having been fully vaccinated, as well as a deadline by which this is to occur. The specific structure of these requirements will vary depending on the approach an individual employer is taking. Some employers require disclosure of status by a certain date, with a subsequent date for all employees to become fully vaccinated. Some employers adopt a simpler structure. The policy also needs to confirm, and this is important, that any information with respect to vaccination status will be treated confidentially and in accordance with applicable privacy laws. This is a hesitation that many employees have with respect to sharing their vaccine status with their employer, vaccination status. And it's important to reaffirm in the policy that you acknowledge and will respect privacy obligations. This also includes emphasizing in the policy that vaccination status will be treated on a need to know basis, that it'll be stored securely and confidentially. Um, the policy also needs to recognize that there will be some employees who may be unable to become vaccinated on medical or religious grounds. We know that under human rights laws, an employer has a duty to accommodate these employees up to the point of undue hardship. And the policy should affirm that the employer will receive and consider requests for accommodation under relevant human rights law. And finally, and this is sort of the key to our discussion today, the policy should set out the consequences of not becoming vaccinated. And those consequences might vary widely depending on the structure that the employer takes and the approach to the policy. In some cases, employers have opted for policies which require education and testing for employees who are not vaccinated, and some employers have determined that in their circumstances that's sufficient to protect the safety of workers. Many others have gone further and said that employees who remain unvaccinated past a certain date, absent valid human rights consideration, will be placed on unpaid leave. And whatever those consequences are, they need to be clearly set out so that employees understand the rules they need to follow and the consequences of not following them.
Again, great information there. So we talked about the why, that was the what, and now we're going to talk about the how. How meaning how should that policy be implemented and communicated to employees. So walk us through that, Porter.
Absolutely. So, as you roll out a policy, there's a few key points to keep in mind. The first is that you need to provide reasonable advance notice to employees. So, this means providing reasonable time in the policy in advance of the deadline for employees to understand the rules and take steps to comply. Policies shouldn't be sprung on employees, whether this type of policy or others, and you shouldn't be enforcing them the next day after the policy is implemented. You should also ensure as you implement the policy that you're treating employees consistently. Consistency is key to the enforceability of workplace rules. And consistency means that like situations are treated alike. It doesn't mean that everyone is treated identically because there may be good reasons in some circumstances for treating different groups of employees differently depending on their duties and the nature of their jobs. But differences have to be reasonable, rational, and not arbitrary. As you implement the policy, you also have to ensure that you're receiving and considering requests for accommodation under human rights law as you're obligated to do. And then, of course, you should be seeking advice throughout from your own labor and employment lawyers with respect to the content and the rollout of your policy. Every industry, every business is different, and different considerations are at play. So you need to make sure that your approach reflects your own circumstances appropriately.
That's excellent. So again, we that was why the policy is a starting point, and we talked about the why, the what, and the how. We're going to move on to topic number two, which is really kind of the meat of this webinar. A reminder before we enter into topic number two, you can ask if you're logged into YouTube questions, and we'll be dealing with those after our third topic. So let's go to that second topic, employees who do not abide by the policy. So here's the scenario, Porter, and we know there's lots of complexity to this, so we appreciate you walking us through this. But here's the assumption before I ask the question, right? I'm assuming an employer has consulted with legal counsel. They've drafted a policy with legal advice. They've clearly communicated it to employees in advance that those entering the workplace must be fully vaccinated. We're assuming here this is a private sector environment, not a unionized environment. And now you have an employee potentially who refuses to provide attestation or proof of vaccination by the set out date in the policy. So now, what should an employer consider before taking any, I'll call it rash action against employees?
Well, it's important at the outset for employers to remember that the goal here is compliance with the policy, and ultimately, in order to protect workers in the workplace. So, the first step that I'd suggest is that employers need to consider whether there's anything they can be doing to support their employees in achieving compliance and overcoming their hesitancy about vaccination. So, are they reluctant to miss work to get vaccinated in the first place, or to risk needing time off because of potential side effects? Is there anything we can offer in support or to reassure employees about that? Having a discussion with employees who are non compliant before the deadline in anticipation of the approach of the deadline can help. At least understand what the nature of the objections are. And for some employees, not all, discussion, education, some kind of support to help them overcome their hesitation, that may be helpful and may lead them to become vaccinated. Some employers might be able to offer support in accessing medical advice. Sometimes it's a lack of knowledge about the vaccine, or concerns based on inaccurate information on social media rather than accurate information from a physician or a medical practitioner. You might have an employee assistance program that can help with referrals or with access to medical advice for those employees who don't have a regular family doctor. All of these steps can be taken in that gap between the introduction of the policy and the compliance date, and can help support employees. The second point to consider is whether an employee has claimed that they have a medical condition or a religious belief, a creed under the Ontario Human Rights Code that prevents them from being vaccinated. If the employee's brought forward a request for accommodation, you do have an obligation to review and consider that request in good faith. If the request is valid and meets the standard to engage the duty to accommodate under human rights law, you have a duty to consider what accommodations can be provided. Can the employee perform their work from home? Can we modify their duties? Can we offer alternative work? If nothing else can be done, then you may determine that you can't accommodate that employee without undue hardship. The duty to accommodate, and it's not necessarily well understood publicly, but the duty to accommodate doesn't mean that we have to expose other employees to a risk to their health and safety. And an increased risk to the health of someone's colleagues is undue hardship within the duty to accommodate analysis. Finally, it's important to remember that an employer needs to exercise discretion and be reasonable in its application of the policy and not mechanistic. For example, if someone comes to you on or immediately before the compliance deadline and tells you they've booked their first dose on the deadline and they plan to receive their second dose, you could consider whether you can let them continue to work while they're awaiting their second dose with other measures to protect safety. If someone tells you they need to talk to their doctor about the vaccine and they need some time to do that, you can consider whether you might be able to extend the deadline for them. So, as I said, exercise discretion, but as I said earlier, be consistent and be reasonable in your application of the policy.
Good stuff. So my words, not yours. I'll just review a couple of the points that I heard. So, of course, we're exploring now the people who do not abide and what considerations to take before taking action. We're going to talk about the potential action in just about 10 seconds here. So what I heard you say is, remember what the ultimate goal is. You're not trying to be punitive, again, my words, against an employee. You're trying to get compliance on a policy. Second, you need to consider if they had a legitimate reason not to be vaccinated. And then third, you need to be reasonable. And I think that's kind of an overarching message throughout all of this. So having taken into consideration all those factors, the question, Porter, is, okay, what action can be taken? You've considered all those points that we just said, and now the action is, give us some sense.
Absolutely. This is going to be dictated by the path you've taken in your individual policy, and this is why it's so important that you craft your policy carefully and with legal advice. If you've told people in advance in your policy that they can continue to work if they're unvaccinated, but they'll be subject to testing, then you shouldn't change direction at the last minute and place them on unpaid leave or discipline them for not complying. Employees need to know what they have to do, as I said, and what will happen if they do not meet that requirement. That being said, the circumstances of the pandemic change rapidly, we know. And if you decide that, notwithstanding an initial approach of testing and continued work, that's no longer appropriate in the circumstances, then you can change your direction. You just have to provide notice of that change and an opportunity to comply with the new rules. So, where an employer has decided that all employees must be vaccinated, in most cases, the appropriate response to an employee who chooses to remain vaccinated, absent human rights considerations, will be an unpaid leave of absence rather than permitting them to continue to attend in the workplace. I do want to stress, though, that these policies are new. This is an evolving area of the law and a whole new body of case law in many respects. And there's little clear guidance from the case law around what is and isn't permissible. Uh, when we're advising our clients on these issues, we're advising them on the basis of past decisions in very different circumstances in many cases. We are starting to see some decisions in the unionized context, early wave of them last week, that are providing some early guidance. And those decisions are recognizing that unpaid leave may be appropriate in some circumstances, may not be appropriate in every case, depending on the circumstances of the employer. The decisions even left open the possibility of discharge in appropriate cases for failing to become vaccinated. What we do see coming out of those early decisions is an emphasis on the importance of the assessment of the actual risks in the workplace and what is necessary to protect employees, clients, patients, public from those risks.
Very interesting again. Interesting to see that the courts are catching up with this as anticipated, and you need to consider risks. That's a really important point. So if an employer chooses to put someone on unpaid leave, I guess my next question would be, how long does that unpaid leave last?
And the answer to that is one of those really unsatisfying lawyer answers that there's no clear answer. There's no bright line. It's going to depend on the nature of the leave and the approach the employers take into the policy. In the case of a non-disciplinary unpaid administrative leave, we can take some guidance from the arbitration case law in the unionized sector. Case law in the past, in different circumstances, has considered what should be done about employees who failed to achieve or maintain a necessary condition of employment. And the key principle from those cases is that an employee must be given a reasonable chance to achieve or re-achieve compliance with that condition. So the analogy and where most of these cases arise, for example, is loss of a driver's license, loss of a necessary professional certification or security clearance. The reasonable length of time that we see emerging from those cases is very fact dependent. And we would anticipate that in the context of vaccination, what is considered to be reasonable might depend on many factors, including the amount of advance notice the employee had of the requirement, the availability of resources for the employee to reconsider their decision, opportunities to become vaccinated, the availability of vaccination appointments themselves, and the timeline required for vaccination. We know that we've seen some employers provide 2 weeks to reconsider and then proceed with a termination. Others have adopted an approach of an unpaid leave without a fixed end date. There may be considerations as well dealing with individual employees, for example, employees who have a valid medical exemption from becoming vaccinated. The timeline for the unpaid leave will be much longer in that case. Um, and will depend on an analysis of whether the employment relationship is frustrated by the employee's inability to become vaccinated.
Okay, good stuff. Good stuff. So, just a reminder to everyone who's watching, you can pose questions through the social media platform. Most of you are watching on YouTube, and I'll be keeping an eye out for those questions, and we'll look for those questions after this topic. So, immediately after this. So, the third topic, as we said a few minutes ago, and I'll just set this up a little, Porter. So if sorry, I'll just say the topic first: how employers can protect themselves against legal actions from unvaccinated employees. So the question obviously is predicated on if you as an employer place someone on unpaid leave. It's possible that employee will respond with legal action. So it's possible placing employees on unpaid leave will lead to legal challenges. As I said, what kind of claims have you seen being raised so far, Porter?
We've certainly seen a lot of activity in this area, and we've heard from our colleagues on the employee side and union side of the bar that they've been very busy on this front as well. We've seen in the non-union sector, we've seen demand letters alleging that placing an employee on an unpaid leave is a constructive dismissal, and so claiming wrongful dismissal damages. And we've seen wrongful dismissal claims arising out of the cases where employees are actually terminated for failing to be vaccinated. Within the unionized context, we've seen numerous grievances challenging the policies, vaccination policies, challenging the unpaid leaves, challenging terminations ultimately. We've seen claims for breaches of human rights, for denials of human rights code exemptions, both in grievances and at least threats of claims to the Human Rights Tribunal as well. There are a lot of avenues available here to employees to pursue relief, and we know that lawyers on the plaintiff side will be very busy on the employee side.
I bet. I bet, and those are the types of claims. So let's talk about, if you're an employer, how can you avoid or mitigate some of this risk?
As I said at the start of our conversation, this is an unprecedented time, and one of the unknowns here is how the courts and how arbitrators and how the Human Rights Tribunal are going to be approaching these issues. No one knows for sure yet how a court will determine a claim that an unpaid leave for failing to be vaccinated constitutes a constructive dismissal, or how an arbitrator will assess a policy that a particular employer has implemented in a particular workplace. But we can reasonably predict that a court or an arbitrator will be looking carefully at the reasons why the rule was implemented. They'll look at the clear evidence of the safety risks from the pandemic and how those risks manifest in the workplace itself. They'll look at evidence of what other measures can be done to mitigate those risks and the effectiveness of those measures. So, with that in mind, the best protection against legal claims, regardless of the nature of your business or your industry, is making sure that the approach that you've taken is the result of careful consideration with the guidance of your legal counsel of your individual circumstances, your individual workplace. Your approach should be based on the best available evidence. You should have considered whether other options short of vaccination are safe and reasonable in the workplace, and you should be able to explain why they're not. You should be able to point to any legal obligations or government direction which requires you to have a policy or requires you to mandate vaccination in the workplace. And you should ensure that throughout, as we've said repeatedly, you're being fair, consistent, and reasonable in your application of the policy to employees. You should also ensure that you receive and consider requests for accommodation under applicable human rights law throughout. And the most important thing, above all else, is just making sure that you stay in touch with your employment and labor lawyer. We can't stress enough that the law in this area is changing more quickly than anything we've seen before. There's a whole new body of law being created around vaccination policies, and your employment lawyer will be able to keep you up to date and well equipped to defend yourself against these claims.
Good stuff. And we're going to move to our Q&A session for a few minutes here. One thing I just want to emphasize that maybe needs to be said is employers aren't getting into the politics of this. The starting point for all of this from an employment perspective is protecting other employees. An employer has a duty to provide a safe workplace. So this isn't whether you're pro-vaccine or anti-vaccine, this is, really about protecting those employers. So it's coming from that perspective. It's not employers getting involved in what sometimes is a bit of a heated debate. But anyway, let's go back, Porter, to something that you raised a few minutes ago. So, and it's the fact that there are valid exemptions for people being unvaccinated. One of those, there's two. Let's start with the first one, and it's a medical exemption. So walk us through, if you're an employer and you talk to the employee, you've got a mandatory vaccine policy in the workplace, and the employee says, I've got a health issue, I can't get it. What should the employer know?
Right. The medical exemptions, thankfully, are the subject of very clear guidance from the Ministry of Health. We've seen a lot of these requests coming in for medical exemptions from employees, but the Ministry of Health and the College of Physicians and Surgeons have provided guidance that there are essentially two bases for exemptions from vaccination, two contraindications to vaccination in adults, and one is an established allergy to a component of the vaccine, which needs to be diagnosed by an immunologist, and the second is a severe adverse event to a prior dose, a severe reaction. So the MOH has set these out in a guidance document. We've seen varying degrees of recognition of these limits from physicians. We've seen some physicians, unfortunately, who've taken a much broader approach that isn't consistent with that guidance. And we've seen the College of Physicians and Surgeons taking action quite rapidly against those physicians to significantly limit their scope of practice. So, your best guidance if you're receiving a medical exemption request is to look at the documented circumstances from the Ministry of Health where exemptions are warranted.
It's good to know those are set out. So there is some clarity on that. So let's deal with the second possible exception. This one, I get the medical one. This one, to me personally, is a little bit more intriguing and complicated, and it's the religious exemption. I obviously understand people have different beliefs, and I respect that. But talk to us about what a possible religious exemption would look like.
Absolutely. The religious exemptions are much more challenging than medical exemptions because they are much less clearly defined. I think religious or creed exemptions is right now one of the most widely misunderstood area of the law, and dealing with it in depth would be a whole conversation on its own, Michael. Um, Ontario's Human Rights Code, for example, protects creed, which lay people might read and think there's protection for any particular belief that they might have, that they believe strongly enough that it constitutes a creed. But creed, the protection for creed doesn't extend to secular or scientific or philosophical beliefs. And if I can borrow a phrase, it doesn't protect alternative facts or belief in alternative facts. It broadly overlaps with religion. The basic test is whether the belief is sincere and genuine and part of a broader religious or spiritual worldview rather than a single issue belief. A belief specific to the COVID vaccine is less likely to be protected than a religious opposition to vaccination, period. Um, the challenge that we have when we're receiving these requests is that unfortunately the code protection for creed is being widely abused by anti-vaccination organizations. We've seen form letters coming out from organizations for individuals to sign and seek a religious exemption to vaccination rather than religious exemption requests that are based on an individual's genuine and sincere religious or spiritual beliefs. From the many that I've seen over the course of the last few months, the vast majority of the requests I've seen don't meet the threshold for protection under creed, fundamentally because they're not sincere. Very few religions are legitimately opposed to vaccination. And while an individual's belief might deviate from their religion's belief, if we have an individual opposing receiving the COVID vaccine, where they aren't opposed to receiving other vaccines for reasons which are articulated on rightly or wrongly on sort of secular scientific views about the vaccine rather than on broader spiritual or religious grounds. Those are going to be much more difficult to substantiate.
And Porter, we've got a little bit of a follow-up question on that one from Benoit Stuke. So thanks, Benoit. So this says, how can employers deal with employees who get that religious exemption? So I just heard from you that it would be very hard to get it, but let's assume that someone got it. So how should employer deal with a non-vaccinated person who has a religious exemption from working around other employees? So, you've got someone with a valid exemption. Let's presume it's on a religious basis, but it could be on a medical basis. How do you protect them or separate them? I guess that's as much of an operational question, Porter, but any quick reaction to that?
Well, it's nice to have Benoit with us today. It's nice to hear from you. That is the subject of some commentary by the Human Rights Commission, which has been quite helpful. And that commentary reinforces a point that I made earlier this afternoon, which is that the duty to accommodate isn't boundless. The duty to accommodate is only up to the point of undue hardship. And so if you have a valid exemption request, whether it's a medical exemption or a religious exemption, and I should say a valid request for accommodation, you have to explore the usual range of options to accommodate that person in the workplace. So if you have a person who is able, because of the nature of their position, their duties, if they're able to work from home exclusively and not attend at the work site, then it may be possible to accommodate them by permitting them to continue working from home and not attending at the workplace. Other employers who have to be physically present in the workplace, other employees, I should say, who have to be physically present in the workplace or out in the community or dealing with clients or patients or customers, it may not be possible to accommodate them by permitting them to work from home. And so, in those cases, if you don't have alternate duties available, you don't have other means that you can accommodate the request to continue working, you may conclude that you are not able to permit them to continue working without exposing other employees to a threat to their health and safety. And if you conclude that there's no way to mitigate that risk to other employees' health and safety, then you may conclude that you've reached the point of undue hardship, and so you're not able to accommodate that person apart from an unpaid leave of absence.
That's very helpful. So again, in my words, what I heard you saying is you should, one, try to accommodate that person. For example, they might be able to work from home, and then you've removed that risk of the virus spreading. And two, if you can't do that, and the person's job entails them being in the workplace, then that might be an undue hardship, and that's when they go on unpaid leave or potentially get terminated. Well, Porter, listen, we've come to the end of our time. You've done a great job. I fully appreciate this is a very rapidly evolving, as we keep on repeating, and complex issue. You know, it depends on all these factors about unionized, public sector, private sector. There are some commonalities, of course, that you walked us through. You've done a great job. As we've stressed throughout, if you're an employer watching, you should get your own legal advice. And of course, Porter's just demonstrated his fantastic expertise in this area. So, Porter, how can people contact you? We'll bring a slide up with your contact info.
Absolutely. I'm happy to chat with anyone who's dealing with these issues. Myself and my colleagues, as I mentioned before, been dealing extensively with these issues with many of our clients for the last 3 or 4 months. So uh, feel free to give me a call at the number on the screen or send me an email, and I'd be happy to chat about it, or one of my colleagues would if I'm not available.
That's great. So, Porter, thank you for your time today, and hope to see you soon. Good luck to all of you and your colleagues at Emond Harnden and in helping employers through these uncharted waters, as they say. Thanks very much, Porter.
Thanks so much for having me today. I appreciate it.
Great. And as you heard, some great advice there from Porter Heffernan from Emond Harnden, a great management side, employment and labor lawyer and law firm, and a great supporter of these series of videos that we're doing with the Ottawa Business Journal. We're going to wrap up now. I did want to point out that this is a live broadcast, but this becomes on demand in about 15-20 minutes, and it will be on many of OBJ's platforms, including YouTube, LinkedIn, Facebook, and Twitter. So you will be able to watch this. We always recommend going to the YouTube. It's very easy to share. If you're watching live, one thing you can do to help us out is give us a like, follow us, and there's a little bell icon that you can click. And if you click that icon, you'll get notified whenever we are live or posting new videos. So thank you very much for tuning in today. This is a series that we will continue of webinars to have throughout the fall. I think we've got 3 or 4 more coming up before the end of mid-December. All webinars that are designed, of course, to help you make informed decisions as business owners and business managers. That's all the time we have for today. Big thank you to Porter and Emond Harnden. Hope to see you real soon. Take care.